Managing Director of SunTrust Bank. Senior reporter Celestine Area reports.
In continuation of his evidence, EFCC's first witness, Suleiman Chiroma, said his company, Finaco BDC Limited, was duly registered with the Corporate Affairs Commission, CAC. Under cross-examination, he admitted that as of 2021, he was a bureau de change operator. He said Alima Buba and her co-defendant, Innocent Magwa, the Executive Director and Chief Compliance Officer of the bank, are not directors in his company. Chirima, who had earlier told the court that he was no longer in business of BDC, admitted that Finaco BDC Limited had not been warned up in accordance with the Companies and Alliance Matters Act. He admitted that he met Aisha Chimugu in 2021 at SunTrust Bank. Also, she gave him the sum of $1.8 million for swapping into Naira and credited her in Naira equivalent same year. He confirmed that he was not at the Lagos branch of SunTrust Bank on March 10th, 13th and 14th, as well as 20 and 24. He told the court that he was invited by the EFCC on April 11th or 12th in respect of the transactions and that he was released the same day. He made about 2 or 3 extrajudicial statements at the Anti-Graft Agency office, and he said the statements were signed by him and the statement formed part of the charges before the court. However, when counsel to the defendant sought to take Chirima on the charge, EFCC lawyer Rotimi Oyedipo objected. Mr. Oyedipo contended that the pages 10 to 12 of the charge are letters of investigation of the EFCC. He submitted that the officer who could certify the documents was the EFCC officer in whose custody the primary evidence can be seen and inspected, upon which payment of the prescribed fee. He argued that the extrajudicial statement of various witnesses can only be tendered upon the satisfaction of the conditions. Justice Emeka Nwite adjourned the matter until 13th October for ruling.
So all we wanted to do was to tender the charge, be admitted before the court, and then we'll do the needful. But the prosecution objected to the admissibility of their own charge. You must know that this charge was filed by them. It is the same charge they are trying the defendants upon.
We believe very clearly that that charge is admissible. We're even surprised that EFCC, who filed a charge, is afraid of the charge being tendered in evidence. How else do you show the documents you have brought to prove your case if it's not in evidence?
The defendants are being prosecuted on money laundering offenses to the tune of $12 million. In the 6-count charge, they are alleged to have aided high-value cash transactions without routing them through financial institutions. Celestina Area, TVC News, Abuja.